scheme of the Internal Revenue Law hasn't changed from 1861. And we showed the first Income Tax Act just a little while ago. Yeah, we showed that just a little while ago, and it said an act to increase revenue from imports. And the first Income Tax Act was called, anybody remember? Income duty. Income duty. And what is one of the questions that naturally you say, well, why doesn't the 1040 that they send you say this is your income duty form for 1994? Right? Because it hasn't changed. The law is still the same from the beginning.
Well, I mean, there's like the enabling statute, there's legislative history, and there's the interpretive case law. So there's a lot more.
That's right. That's right, and it all says the same thing. I did a talk show a little while ago in New York City on WOR, 3-hour talk show. Wait, hold on. Let me see. WOR. Well, what I'm showing you is as you go through, this repeats itself over and over again. That's what I'm showing you. And every authority you dig out and show, it goes back and proves itself. So what I do in all these talk shows, and I'm going to do with you here tonight, we have a standing offer of $10,000 for anybody to prove me wrong. It's been standing since 1982. We have some lawyers that come forward and try to collect it, and they all failed. And I tell people on the air that, we have a standing offer of $10,000, and we want people to go prove us wrong, because we want people to go back and dig in the law. That's why I stand up here and take great detail to point all these things out, because I want you to understand. So that was about a month or so ago, and just last week, the phone rang, and I answered, and it sounded like a young gentleman, and he said, "My name's so-and-so." I said, "Yes, sir." He said, "I heard you on Gene Burns' show." And I said, "Thank you." And he said, "You said prove you wrong." And I said, "Yes." And he says, "Well, I went to the law library. I'm a law student at Columbia." I said, "Well, how'd you make out?" He says, "The harder I tried to prove you wrong, the more I proved you right." He says, "This is mind-boggling." He said, "How can this be?" Some time ago, Dominic LaPonzina, who's the public affairs officer for IRS in Baltimore, was on the air, and I got on with him, and I offered him to come up here and debate me and show where I'm wrong. And, of course, Dom didn't want to hear that. I can't talk. I said, well, the first thing I did when I got on, I said, I waive all my privacy rights. You can talk anything you want about me, because I waive all the rights, and that's standing. Just come up and debate me, and we'll put it on videotape. Prove me wrong, Dom. And all he did was call some names and hung up real fast. So he really, if you remember, some of you might have heard that. In fact, we have tapes of it. He didn't do himself any good, to say the least. So anyway, he recommended that some lady tax attorney come on and tell the IRS's side of things. So they had her on there. So I called up. I wasn't on the show with her. I just called her up, right? Now, she's the expert. The IRS says is the expert. And I asked her just 2 questions. I said, "Can you tell me how many chapters are in Subtitle A income tax?" So she snapped back, "You got the book in front of you. You tell me." Well, I didn't have a book in front of me, but I didn't have to. I said, "It's 6. 6 chapters in Subtitle A." I said, "Now can you tell me where in those 6 chapters do we find withholding of income tax on United States citizens?" Dead silence. What I just said. Tell me, listen carefully what I just said. Tell me where in those 6 chapters of Subtitle A income tax do we find withholding of income tax on United States citizens? Dead silence. I just let her hang for a little bit. Then I said, "Well, can you tell me?" Dead silence. And I said, "There is none. It doesn't exist. It's not there." Okay? If the citizens owed the tax, they would be withheld from. It's not there. We just looked at who the withholding agent, who withholds the income tax, who is he authorized to withhold from. You didn't see citizen there, did you? It's not there.
Also, John, I believe a lot of people open up the book when they start studying the code, and they start looking for something that says that citizens are not liable. If the law doesn't apply to you, it doesn't have to say anything about you.
First off, if we're going to, well, one of the persons who belongs here has been going over, the individual has been going over to the Library of Congress and digging into Social Security. And he's going back to the notes between the Secretary of the Treasury and the congressman on the committee when they were writing the law. Right, back in the 30s. And he brought me documents and showed me documents of these notes and these letters back and forth where they were discussing how they were going to write the law so that they could get the people to believe it was required when it wasn't. Huh? And he's writing a book on this, which we're going to publish for him, producing these documents.
When is it coming out, John?
Well, he has to finish the book. Huh? First of all, he has to finish the book, and then we have to edit it and check it out. I mean, it just things like that don't go like this. You see what I'm saying? I mean, you can go to the library, you can dig and find these things. What we have in this country is we have the blind leading the blind. They have a mindset which has no relation to the law whatsoever. We've been asking questions of the IRS. I've been studying this for 25 years. And all the time I've been asking questions, and they have no answers.
Well, you would know more than an attorney right out of law school, that's for sure.
We have attorneys who come here and ask us to show them the tax law. We just had one flying from California and ask us to show him the tax law. You know what it says in the regs about Subtitle A. In 1.1441-5, it says very clearly, a person claiming not to be subject to withholding of income tax gives a statement of citizenship to the withholding agent. Very clear. We can show it to you. A person claiming not to be subject to withholding of income tax gives a statement of citizenship to the withholding agent. And then the withholding agent relieve the duty of withholding tax. We're going to show that. Yes, sir.
When did an income duty become an income tax? When was that changed?
Well, when the Congress wrote the law and left the word duty off. But in essence, it hasn't changed.
So that in the definition section, it says income tax is an income duty, in essence?
No, the code, the section was called income duty. Today it's just called income tax. They left the word duty off when they rewrote different sections. All right? So here we're still in 3451, which is in subtitle C, and there's no longer there, right? I mean, surely, if there was any authority, why not some other one? Now, the reason why I'm saying that is because, what about section, you're familiar with section 3402? All right, so we'll get into 3402 a little later. Evidently, it's in the same chapter and verses, 3451. All right, now we have 1461, which is the last one, right? Liability for withheld tax. Every person, now look at this carefully now. Every person required to deduct and withhold any tax under this chapter is hereby made liable for such tax and is hereby indemnified against the claims and demands of any person for the amount of any payment made in accordance with the provisions of this chapter. Source, section 143C, 39 Code. Okay? Now, these are all from the 1954 Code 82 edition. What I want to bring that to your attention is because later on I'm going to show you where in the 90 edition of the 86 Code, you can no longer find references to the 39 Code.
Why?
But it's still unchanged.
Huh?
Still unchanged?
Why? Because that prevents research. That prevents you from going back. So if you have a 39 code, you can go further back from that.
But the source even today is still the 39 code?
Oh yes, it hasn't changed, substantially unchanged. It would have to say changed, but it hasn't changed. And the 39 code is very explicit, more explicit than, in fact, the 39 code explicitly shows you what income is within the law, which a lot of people don't even understand what income is. Income is not defined in the code. Gross income is defined, but not income. And in the 39 code, it shows you what income is. And what they did is when they brought it over to the 54 code, they dropped the part that showed you what income was. But they said substantially unchanged. So we're going to show you that a little later on.
So what does this section mean here? You read it, but...
What, 1461? Well, it's the liability of any person who is a withholding agent. Well, who's a withholding agent?
Someone dealing with a foreigner, non-resident alien.
Anybody. All right. Let's say Ronald here, who's an Englishman. Let's say Ronald here, he's living in England, up on the Scottish border. Right? And Ronald owns a house in Annapolis. And it's not doing him any good up in Scotland up there. So Ronald wants to sell me that house. So I buy it from him. I want that house. Man, it's a nice house right on the water, sitting on a point looking out across the Severn River. Watch the sailboats going by. Beautiful place. All right, so he wants to sell that to me. And I buy it. When I pay him, what do I have to do? I have to withhold 30% because just by the act of buying that property from him, I become a withholding agent.
You're dealing with a non-resident alien?
Of course. Doesn't it tell you have to withhold from a non-resident alien?
Sure.
Isn't that what it says? Well, if I'm paying a non-resident alien, then I'll have to withhold from him. Right? It's just that simple. And that's what it's saying. It says every person required to deduct or withhold any tax under this chapter. What chapter are we talking about?
26.
Huh?
Chapter 3.
Chapter 3?
Chapter 3. Chapter 3. Now this is the 54 code, 82 edition, and yet it's showing you two chapters. And it says in the language, this chapter. Huh? Is something wrong with that?
It appears to be wrong.
Right, something appears to be wrong. It hereby made liable, right, for such tax, so I'm made liable for it. If I don't deduct it from him, it comes from who? Comes from me. 30% of what I gave him. Everybody understand? See it? And is hereby indemnified against him. All right? This is very important. This part of it's very important too when we get to subtitle C. All these things I'm pointing out, you keep in mind. Is hereby indemnified against the claims and demands of any person for the amount of any payments made in accordance with provisions of this chapter. All right? So they could be anybody.
But we're also dealing with income tax here. That term indemnified.
Well, this is income tax.
Right. So that term indemnified, does that mean that even if you made a mistake and withheld too much from the non-resident alien?
No, because the law tells you to withhold 30%.
Oh, okay.
You got to go by the law, which tells you how much to withhold.
So if that non-resident alien has any complaints or anything to say, they can't come back at you
No,
for that?
no. All they can do is file a 1040 NR for the return of some of that money. If they don't file a 1040 NR, what can happen?
Okay, but that mentions that for the purposes of this chapter, in the title, that
Well, this chapter would be what? Chapter 3. See the 14?
And the withholding
But
agent.
yet here they're talking also about a code section in another chapter. Go ahead, finish it. Go ahead.
Well, indemnified means that the person you're withholding from can't come back at you.
That's correct.
Someone like me who's lived and worked in the United States all my life,
All right.
if I found out a withholding agent was withholding from me, that kind of leaves the door open for me to sue him or something because
Well,
it's something that didn't apply to me.
what does the Fifth Amendment say? What does the Fifth Amendment say?
Due process.
What does the Fifth Amendment, is that all it says? What else does the Fifth Amendment say?
Due
The
process.
person shall be deprived.
Oh, here it is. Who's saying it?
I haven't started. No person shall be deprived of.
Any property without due process of law. No person shall be deprived of any property without due process of law. Who's it talking to? Who does the Constitution pertain to?
The United States.
United States citizens in the states of the Union. If you're a citizen of the State of the Union, would he be if he's a citizen of England? No. I'm indemnified against him. But I wouldn't be indemnified against you because you have to have due process before I can take any property from you. That's a protection of the Constitution that you have. Right? Everybody understand that? But he doesn't have that. Would a citizen in Puerto Rico, would they have it? No. They don't have it either. They're the subject of Section 911. That's withholding of tax on them. It says Puerto Rico, all of them, you know. They're 911. But it doesn't say any citizen of the State of the Union because that doesn't exist.
So being indemnified, that means like there's a hedge around you and you can't be.
You cannot be sued for doing it. He can only go to the IRS and try to get some back from them through deductions or allowances or whatever.
But if I wanted to as a citizen, because he withheld from me improperly, couldn't I sue him?
Yeah, if you're a citizen can sue for the return of his property. He has standing in court to sue because he was denied due process.
So shouldn't it be important for an employer to understand that right now, or a withholding agent to understand that right now?
Well, is an employer a withholding agent?
Well, not necessarily, but.
Well, I mean, first of all, that question has to be answered, and the employer would have to be examined. Where do we find withholding agent? Where do we find withholding? Subtitle A. Do we find withholding agent anywhere else?
No.
No. A withholding agent withholds the income tax. What does an employer withhold?
Employed.
Employment tax. Never the twain shall meet. One's in subtitle A and the other is in subtitle C.
But the employer has the right to take out that withholding if you do not submit that certificate.
By what code section?
3402?
No, 3402 says he doesn't have that right. He has the right to withhold from you only when you give him a W-4, 3402 says.
No, it says if you don't file a W-4, as an employee, he's supposed to take out a tax for maximum.
No, we just won a case down in Texas on that. No way. 3402 clearly says he can only withhold when he's given permission by the covered employee by the means use of a W-4. W-4s are not used in subtitle A, they're only used in subtitle C. Well, how do you know that? Thank God for the Paperwork Reduction Act. That tells you. That's when the IRS had to obey the law. I mean, that's when the Congress made a big mistake with the Privacy Act and the Paperwork Reduction Act because it locked the IRS down and they started fessing up to how they were robbing from people. That was the beginning of fessing up because they had to give an OMB control number that went back to the statute that authorized the use of the form. And W-4s are only in subtitle C. Right? 1099s go to subtitle C, but they also go to 1401 for self-employment. Okay? W-2s only go to subtitle C. When you trace them back and go through the regs, that's where they are, subtitle C. We did that some time ago. Billy spent, a couple weeks on that, just compiling all that, and we have it somewhere around here in the computer.
I remember where I saw that. It was in one of the pamphlets to the employer. where it said.
Oh, you mean a publication?
Yes.
Oh, well.
Yes.
A publication is not the law. They say a lot of things in publications.
What did you say the law is on the 1099?
What did I say? I said it goes to subtitle C, but it also goes to 1401,
Which names?
self-employment.
Okay.
We just covered that a little bit ago, right? Okay? Okay. All right, now, we just looked at the code section, and all we could find is foreigners, right? We couldn't find any citizens. So now we've been through the code, and the code, you know, the Constitution, right? There's one piece of paper under glass in Washington, right? Now, from that one piece of paper under glass in Washington, we have all kinds of laws that come from the federal government, right? I mean, the Internal Revenue Code, the copy I keep on my desk is about that thick, okay? It's just Title 26. If you have all 50 titles, you know, they take up a shelf. Now you would have the regulations that implement the code sections, right? Now, you might have a code section. As we saw, code sections are like one paragraph. Well, good Lord, for that one paragraph, you might have 20 pages of regs to show you how to implement that. Not only there, but it's in different parts for different applications of that same code section. So the regs, I have the entire regs for Title 26 on my shelf, and they're that long. So you have the code like this and the regs like that. Now, notice as the volume expands, right, it's in more detail. These code sections they're fairly vague, you know. You can pick through them and really work them over, but they're fairly vague. Now, that's why you have regulations to implement them. The regulations tell the person within the agency how to implement the code section. So they're more explicit, more in detail. And then within the Internal Revenue Service, you have the Internal Revenue Manual. Now the manual is 8 feet high and 9 feet long on the wall. Okay? 8 feet high and 9 feet long. Where would you think you'd find the most? In the manual. The manual would tell you more than the other two, wouldn't it? They had to have something on all those pages. Right? By the way, we have all 50 titles on CD plus our manual on CD. Can you imagine putting all that on a little disc like that? It's hard to believe, but it's at our fingertips. All right, what we're going to do is we're going to go to the manual. And we're going first to chapter 1100. Chapter 1100 is called Organization and Staffing. What it tells you, the organizational history, establishment of the Internal Revenue Service, the mission. Well, what we're going to look at is the Organic Act. Right here, Organic Act. The office of the Commissioner of Internal Revenue was established by an act of Congress, 12 Stat 432, on July 1st, 1862. The first Commissioner of Internal Revenue took office on July 17th, 1862. Now, why was that? Why was that? Why doesn't this say the office of the Commissioner of Internal Revenue was established by an act of Congress on July 1st, 1787 or 1789?
Because,
Huh?
was it called the Bureau or something then?
That was when the first income tax was.
Well, no. Does the Internal Revenue Law only pertain to income tax?
No, it pertains.
No, it pertains to all kinds of different taxes, right? Why doesn't it say July 1st, 1789?
Because we had no internal taxation until then.
We had no internal taxation on a permanent basis until 1861. There was no internal taxation.
They were raising money for the Civil War.
For the war between the states, right?
That was the sole purpose of it.
But it stayed, didn't it? Right? What is the? That's right. Well, what is the history of internal taxation? Does anybody know the history of internal taxation? What was the first internal tax after the constitutional republic? Anybody know the first internal tax?
Whiskey?
That's right, whiskey. And then they had what? A rebellion. Well, what was the history of that whiskey tax? Does anybody know the history of that whiskey tax? When you deal with the history of the first internal tax, you're dealing with the political attitudes of the founders. Right? That's what you're dealing with. And you have to understand the history of the Confederacy, which preceded the Republic. When you know the history of the Confederacy, one of the main problems in the Confederacy was that Congress would lay a tax on the states, and the states would laugh at them. They wouldn't bother to collect the tax. And Congress had no enforcing power. That was one of the problems of the Confederacy. You got to have government, and you got to have taxes. But only those taxes that are what? Just and necessary. Just and necessary. Not just tax you to death. But anyway, so you have to understand the political background and history of the first Secretary of the Treasury. You know who he was? Alexander Hamilton. Hamilton was a monarchist. He didn't believe in a republic. Remember, Hamilton was the one who wanted to make George Washington a king before he resigned his commission. And Hamilton didn't believe that the average person could govern himself. He didn't believe that. And he believed heavy in the aristocracy. And he was the one who agitated that they just tax anything, even though they didn't need the money, to show the people they had the power to tax them after the Constitution. That's why him and Jefferson would argue all the time, as Jefferson didn't believe like that, you know. He believed in the average man could govern himself. So that was the history of it. They just laid the tax even though they didn't even need it, just to show that they had the power to do it. And they even spilled blood to do that, because they had to take up arms to put down the whiskey rebellion. Well, you say, well, why did these farmers get all upset about a tax on whiskey? Why would people want to spill their blood for a little tax on whiskey?
It was their livelihood. It was their livelihood.
That's right.
They just got rid of England. That was the whole big deal.
Well, it had more to do with that. It had personally affected their livelihood. Because at that time, there was very little coins around. And money was precious, right? And what these farmers used to do is all winter long, they would make whiskey from the grain from the year before. And then in the spring, they would take the whiskey down to the marketplace and sell it to buy seed for the next year. And a tax on that seed, so to speak, hurt the farmer. And it put an imposition on him to the degree that he wanted to fight to stop it. And they did, but the government put him down. That's when a militia fired on the citizens. Is there a precedent? Yeah, the Whiskey Rebellion. Would it happen again? I don't know. Everybody is aware that the Marine Corps in California was just given a survey to answer. Everybody aware of that? Yeah. The survey said, one of the questions on the survey was, if firearms are outlawed, would you fire on a citizen who refused to surrender his firearm? That was one of the questions on the survey.
What'd they answer, John? What did they answer?
Nobody knows. That hasn't been released. The only reason why we know there was a survey, because one of the Marines had enough foresight, he took 2 survey papers and turned in one, and the other one he smuggled out and gave to the media. And this paper out of Washington published it, and after the paper published it saying that it was smuggled out, 2 weeks later, the Navy Department admitted that the survey had occurred. So now they got confirmation that this survey, and that was not one of the questions, there was other questions like that on there. I think there are very dangerous trends within this country going on right now.
The Navy SEALs were told in a lecture by one of their commanding officers, some of the top-ranking SEALs were told, and I had this on a good source, they were told that the future for a guy, a career or a lifer Navy man was very dim in terms of promotions if he did not understand this was part of the future.
Yeah, I wouldn't doubt it. I wouldn't doubt it at all. Just 2 weeks in July, President Clinton revised the executive orders to give FEMA powers not only in time of emergency but now in time of peace. He put the word peacetime in there. Just in July. So we better wake up and really get to our neighbors and show them, something's going on, and you got to become aware of what's going on, because, all these things, all these people talking about concentration camps, they all can't be goofy. They all can't be kooks, particularly with this type of thing going on. I mean, it just tends to say, well, there must be something out there if they're asking people questions like that.
Well, that's what happened with the Soviet Union. The Soviet soldiers refused to fire on the citizens, and that's when the regime collapsed.
Just a few years ago you're talking about. Right. That's correct. That's right. It has to
when
collapse.
the tanks refused to fire on citizens, that was the end of the country.
Just the opposite in China.
Right.
Right.
That was the end of democracy in China.
No, the attempt for a democracy. Of course, they have total democracy.
But the reason for that poll would be for re-education of the troops. If they found that most of the Marines would not fire on the citizens, they would say that they would have a problem, and they would go and implement training programs.
Probably so, psychological training programs.
That's part of it.
Oh yeah, I agree with you. I agree. It's there are signs that we must look at seriously. All right, now let's look here. So we understand now that internal taxation started in 1861, right? 62, I'm sorry. Internal taxation. Well, there's another one there. Here, the law was passed in 61 and it started in 62. Everybody remember that, right? What happened in 61? Well, the war started, but something else happened.
They stuck at a first income tax law, didn't they?
The first income tax law was repealed and reenacted in 1862. The first income tax law which was never imposed, was on the Army, the pay of Army officers. And they never imposed it. All right, now here we have internal taxation across the page here. Madison's notes on the Constitutional Convention. What are Madison's notes on the Constitutional Convention? Remember them? No. Madison was one of the delegates to the Convention of 1787, and he took copious notes. And his notes are the intent now of the Constitution. That is the intent. They were, that's right, the intent. Well, it's the only intent. The original intent is the only intent. If it changes, then it's not worth a hoot and holler. Right? Law doesn't change because in the United States, under a constitutional republic, law is written. It can't change. One time I had a judge who had lectured a group I was with, and he taught constitutional law at Troy State University in Alabama. So when he got through lecturing, I stood up and I said, "Judge, can I ask you some questions?" He said, "Sure." I said, "Isn't it true that if the intent of the law is the force of the law?" He said, "Well, that's right. The intent is the only intent." The original intent is the only intent. The intent, well, it's 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 And he says, well, we'd rather think of it as the spirit of the law. I said, now come now, Judge. Isn't it true that when a legislative body passes a law to do a certain thing, that's what that law is supposed to do? So therefore, the intent of the law is the force of the law. Is that correct? Finally, after 4 or 5 times of that, he's finally said, okay, the intent of the law is the force of the law. I said, well, now that we've settled that, isn't it also true that if a law is written so that the average man cannot understand it, it's void for vagueness? He said, well, everybody knows that that's a principle of law. I said, fine. If the intent of the law is the force of the law, and if laws are written so the average man cannot understand them, they're void for vagueness, why do we have case law?
Marbury versus Madison.
I understand, but his face got red. His face got red.
Well, it's a reasonable man standard.
A reasonable man, but if we have written law, you don't have a reasonable man standard. You have the law and it means what it says.
It goes back to English common law, though. That's the way.
Well, the English common law, but I'm talking about constitutional law. I'm not talking about common law.
Well, it embodied, though, English common law.
Well, I understand, but they have case law on constitution.
Well, for instance, there are words that are due process, for instance, the 14th Amendment.
I understand.
I mean, there are lots of things that need interpretation.
Well, then they're void. Oh, well, they're void. Because every law has to be written, and if you have men telling you what the law says, then you're not under a written law, you're under the man who's telling you what the law says.
Well, under Marbury versus Madison.
I understand that. That's just another court case.
Well, it was unfortunately a very powerful one.
Well, it doesn't matter. It's just another court case. That's all it is. It's just one man telling us what he says the law says. The dictionary tells us. We just saw where we went through and saw definitions of the terms.
But it's been accepted for 200 years.
Does that make it right?
No.
The only reason why it carries on is why? Because young lawyers are taught that's the way it is and they follow along.
Well, it's more than that. I mean,
More than what?
Well, the courts enforce the courts get.
Well, who are the courts but lawyers? Well, lawyers. Well, there some lawyers who might be politicians. I think most judges are politicians and lawyers. Well, that's what I'm saying. But there's nothing wrong. We need lawyers, but we need lawyers to obey the law and not change the law. You know what the founders said in Madison's notes? He said the one thing that they feared that would destroy the republic is the sophistry of the courts. That's in the notes. And that's just what you and I are just talking about right now. Because the law is changed by man's interpretation, not by the intent of the law. Very dangerous to freedom. Very dangerous. And a case in point would be Congress under Article 1, Section 8, Clause 5 has the power to coin money. Where are the coins? Case in point of sophistry of the courts. Okay, we got to go on. Let's go back to Madison's notes. The Constitutional Convention revealed clearly that the framers of the Constitution believed for some time that the principal, if not sole, support of the new federal government would be derived from customs, duties, and taxes connected with shipping and importations. What's wrong with that?
There's no mention of internal tax.
Well, sure it is. That's all it's talking about, internal taxation. What is wrong with this sentence? It said, let's look at it again. Madison's notes on the Constitutional Convention reveal clearly that the framers of the Constitution believed for some time that the principal, if not sole support of the new federal government, would be derived from customs, duties, and taxes connected with shipping and importation. What's wrong with that?
I don't think that's what they believe.
They believe.
Huh? They believe for some time? Is that correct?
They always believe.
Who put those words "for some time" in there? Huh? All right. To understand what I'm saying is, when did we get internal taxation? 1862. When was Madison's Notes published? Yeah. Well, when was Madison's Notes?
Upon his death.
Huh?
Upon his death.
Upon his death. Which year was what?
1835?
1730. I'm sorry, 1835. You're correct. 1835. We got internal taxation when? Madison's Notes doesn't say anything about it. We need internal taxation. And after some time, we're going to need it. The IRS put in there for some time. All the framers were dead in 1862. Everybody understand what I'm saying? They were all dead. His notes doesn't say anything about that at all. Okay. Now, we're going to go further in chapter 11. I remember we said that's organization and staffing. It shows you other things. It shows you how all the regions of the Internal Revenue Service are divided throughout the United States. It shows you how the Internal Revenue Service is structured. Everything you want to know about the Internal Revenue Service, you find in Chapter 1100, Organization and Staffing. If you have trouble with somebody down here, you can go right up the line and talk to his boss, and we frequently do. So having Chapter 1100 is very useful in this office anyway. You'll notice if you go through our offices where we have our cubes where all our caseworkers work, some of the caseworkers might have the United States and the different regions up there. It helps the new caseworkers to understand what district office goes with what service center when they're making requests. And then it also tells us the different authorities for all the different branches and divisions of the Internal Revenue Service. All their functions and how they're to do their job is all in 1100. And we want to examine one of these right now. We find it in 1132.75 in Chapter 1100. And it's called Criminal Investigation Division. And it says, the Criminal Investigation Division enforces the criminal statute applicable to income, estate, gift, employment, and excise tax laws, other than those accepted in IRM 11-1251, which is BATF, alcohol, tobacco, and firearms, involving United States citizens residing in foreign countries and non-resident aliens subject to federal income tax filing requirements.
Somebody's missing there.
Huh?
Somebody's missing.
Who's missing?
50 states.
Huh?
Citizen working in the state.
But it doesn't say citizens within the states of the Union, does it? No. Now, I've written to the IRS quite frequently over this section right here. And in fact, when they come out and rapped on my door and said I was under criminal investigation, I said, well, I don't understand. I said, the only authority I can find for any investigation is citizens in foreign countries. And I'm certainly not in a foreign country. I'm in the state of Maryland. Would you please show me something else that would show me you have the authority to investigate me? And that's ever been since 1987. And they have yet to come up with that. In fact, if we have any of our members who are under criminal investigation, I take power of attorney and I start asking these questions of the special agents. And they just, there's no answer from them. You get a response back saying, we don't answer questions on a point-by-point basis. The mission of the Internal Revenue Service is for highest possible voluntary compliance. Well, I say, I agree with that. That's the mission. I agree with that. Voluntary compliance, right? No problem at all. Just show me where I'm required to volunteer. Number one. Number two, show me your authority to investigate me. They have yet to come up with that. Yet to show me any authority. Now, also, what I might add is when you search the charts and you go back to the authorities, even in the manual and the regs, what you find is that all the district offices and all the criminal investigation division district offices come under the Assistant Commissioner International. He's their boss. Every time you look it up, it comes back and matches the scheme, which is citizens abroad, foreigners at home. And that's been the scheme ever since income duty of 1862. And it hasn't changed that I can find. Now, I told you that I represent people before the Internal Revenue Service. And of course, right now they're trying to fight my power of attorney. They don't like the way I represent people. You know, and they're trying to say I don't have the right to represent the members of the fellowship. Of course, the regs are very clear. It says an officer of an organization can represent the organization. But they don't want to agree with that, and they're trying to fight it. But there are some appeals officers who do abide by the power of attorney, and we do go to these appeals conferences. And I have one hearing to show you of some of the responses that we get back from these people after we show them the law. Such as when I go to an appeals conference and it has to do with an IRS assessment. The law is very clear that a citizen within the states of the Union cannot be assessed. And I can show them that in one code section. And I normally do. And in fact, when we respond to the 30-day letter, that's our response, is you don't have jurisdiction to send it a proposed assessment determination of deficiency. And then when we go to argue, we show them the law from one end to the other. And I was kind of tickled that this one up in Long Island, New York, just a month or so ago. I went up to the appeals conference, and my wife went with me, and the Patriot, who they were trying to assess. And I go in there, and so I opened my briefcase, and I pulled out my code book, and I opened the code, and I just opened it real fast and started reading from the code. And after I read it all to him, and I explained why I was reading it to him, and how he didn't have the authority, and I turned it around to him, and I said, see, you can read for yourself just to show you that I'm not misreading the law. I said, no, I'm not misreading this. That's what I said. And he looked at me and he says, we don't go by that tax protest stuff. I said, what you say? He says, we don't go by that tax protest stuff. So I flipped the cover over and I held it like that. I said, it's the Internal Revenue Code tax protest stuff? And he goes like this. Oh. And then it started changing, you see. Right? He couldn't believe it. But anyway, here's an example of just one of those reports. You look down here at the bottom, this lower paragraph, it says, this is a report from an appeals officer after a conference, right? Taxpayer's position. The taxpayer wrote letters on November the 13th, 1991, March 31st, 1992, claiming that he is a citizen of the state of Hawaii, not subject to withholding, not an alien nor a citizen of the United States living and working abroad, does not reside in Washington, D.C. or in a federal enclave, nor an employee of a state or a federal government. He also questions statutory authority for investigative authority regarding correspondence letters. He revokes and rescinds his signature on his previously filed returns, as well as revokes his application for Social Security number, which he acquired as a minor. He also provided us with John B. Cutmar Jr. letter, dated March 3rd, 93, that protests the adjustments with no basis other than citing statutory authority.
What genius wrote that?
Well, that's the kind of things you get back. See? No other authority but the statute, the law. See, we protest with no authority but the law. All right? Interesting, isn't it? Anyway, I thought I would show you this code section. It's in Chapter 68, additions to the tax, additional amounts, and assessable penalties. All right, we're talking Section 6654. Now, this is copied out of the 54 Code 82 edition. Now, they moved this particular code section right here. If you would look at it in the 86 Code, it is now called 6654E, where in the 82 edition it's H. And it says here, failure by individual to pay estimated income tax. Additions to the tax. In the case of an underpayment of an estimated tax by an individual, accepted as provided subsection D, there shall be added to the tax under Chapter 1, that what subtitle's that, A, right? And the tax under Chapter 2, subtitle A, for the taxable year, the amount determined at an annual rate established under Section 6621 of the Internal Revenue Code, which is subtitle F, right? Down here it says exception. There's an exception to this. Where no tax liability for preceding taxable year. No addition to the tax shall be imposed under subsection A for any taxable year if the individual did not have any liability for tax for the preceding taxable year. All right? The preceding taxable year was a taxable year of 12 months. And 3, the individual was a citizen or resident of the United States throughout the preceding taxable year. Huh? What did it say? No, not everybody. A United States citizen or a resident alien in a foreign country isn't. Right? But in the states of the Union, they are accepted. Well, why is that? It's very simple. Now we're going to get into IRS assessment procedures. In 1983, I received a notice of deficiency from the Internal Revenue Service claiming that I owed $640,000 in taxes for 2 years, 75 and 76. I mean, they thought my name was Rockefeller, right? Anyway, so what I started, first of all, what I did was, before the 90 days elapsed, because I didn't have the knowledge that I have today about the code, and before the time elapsed, I petitioned the tax court. Now, today I wouldn't do that, but I did then. So the first thing that happened at tax court, we went and we had stipulations. Before you can go to court and have a hearing, you first file your brief, and then you have stipulations where you get together with the government and you see what you agree on, so you don't waste the court's time by arguing things that you agree on. So through the stipulations, the IRS dropped the assessment, and I did an affidavit removing myself from the tax court, which there's no provision to do that, and I just did it outside the rules. See, the tax court is a fact court. It's not a law court. The tax court cannot subpoena you. It cannot summon you. You can only go to the tax court by your own petition. That's the only way you can get there, by your petition. And when the government sends you a notice of deficiency under Section 6212, what they have to do is they have to tell you all your appeal rights that you have. And they don't do that. All they put in that notice of deficiency is you have 90 days to petition the tax court. They don't tell you that under 6213B, you have abatement. They also don't tell you you also have an abatement under 6404A3. So they leave those sections out. So when they do that, they're in violation of your due process rights, because they're supposed to tell you all your appeal rights. But anyway, they don't do that. So I removed myself from the tax court, and then the tax court after that, after a few letters back and forth, they had an in-bank review of my case. And one night my wife and I were sound asleep, and the phone rang about 1:30 in the morning. And we were both jumped, it was sound asleep, we jumped up and like this, and she ran over and grabbed the phone, and some guy says, "How does John like being on the Wall Street front page of the Wall Street Journal?" She says, "Okay, fine," and hung up the phone. We went back to sleep. So the next morning, we got up, and she related that to me, and I said, "What's he talking about?" So we had to go out and buy a Wall Street Journal to see what was going on. Well, what happened was all the judges in the tax court took my case and tried it without me being present, and they come to a determination that I owed the tax, but I didn't owe any penalty because I didn't intentionally not pay the tax. I just did it because I was wrong-headed and bullheaded. All right? So anyway, so they eradicated all the penalties. So what hell was some $3,000 supposedly that I owe? All right, now after that, I started an investigation into the procedures because I had found out that there was a form called 23C. And a 23C is a certificate of assessment. And I found out if there's no 23C, then there is no assessment. Now, but the way the law was written, it's very misleading, and I was under the impression that a 23C pertained to me personally. But after a while, it started coming through after we were corresponding back and forth that it couldn't. You see, there's only one person who can assess a tax in the Internal Revenue Service. The tax court, there's a misconception of a lot of people have. They think if they go to tax court and all the facts are tried, that the tax court assesses the tax. It doesn't. The tax court makes a finding of fact. The finding of fact is sent back to the Internal Revenue Service, and the Internal Revenue Service in the accounting branch, the chief of the accounting branch, assesses the tax by signing this form 2162, the summary record of assessment, and form 23C, the certificate of assessment. And that's how the tax is assessed. It's not assessed before that. Now, under the impression that I was under, that there was a 23C with my name on there, I requested that document because I knew if they didn't have it, then I had them. And here was the response to that request. In response to your request, I am enclosing a copy of Certificate of Assessments and Payments regarding John B. and Nancy L. Cutmeyer. The certificate pertains to the years 75 through 86. We appreciate the opportunity to serve you. Now, what I asked for was a certificate of assessment. They sent me a certificate of assessments and payments, which is not quite the same thing. Here's the document that they sent me, okay? So I looked at this, and I noticed first off that it was in columns. See how it's in columns? And I noticed right at the top on 2/23/83, they said that a tax return was filed. All right? And that there was no assessment, right, as we come across, no credits, no balance. There was a long number here, which I didn't understand what it was at the time, so I just disregarded it. And then I noticed over here it had 23C date, 5/16/83, and then it had the period, which was 75/12 for the year 1975. Then I looked down here and I saw that on 3/23/83, they said that another tax return was filed. And across there was no assessment, no credit, no balance, and another long number. And I noticed the 23C date was 3/23/83 for 76/12, year 1976. Then I came down here and I followed it down to where I saw that there was a audit tax deficiency for $3,428.11. And on that they put a delinquency penalty and a negligence penalty, $5,324.12. Now, the first thing I thought there, number one, was, how do you get a deficiency of $3,000 from nothing? That's the first question, right? The second question was, who filed these returns because I didn't? It gives a date that a return was filed on. I haven't filed a return in 20 some odd years. So I knew it. I didn't file it, right? And then I noticed at the bottom, it says, I certify that the foregoing transcript of the taxpayer named above in respect to the taxes specified is a true and complete transcript for the period stated. And all assessments, penalties, interest, abatements, credits, refunds, or advance or identified payment relating thereto, as disclosed by the records of this office, as of the date of the certification, are shown therein. Now, what's that saying? It's saying that every document, at least the way I read it, every document that has to do with this assessment is shown on this transcript. Is this a transcript? What is a transcript? Anybody know what a transcript is?
When you transcribe something, you take it and put verbatim what someone said, or
It's an exact duplicate of something. So this is a transcript of what?
Your file, I thought.
Well, would that be a transcript? Is that an exact duplicate?
This is a summary.
It's a summary. But yet they're calling it a transcript. That's the first thing you say, well, what is this? The transcript is the exact duplicate. This is right? Okay. And then I saw that she says everything's on here. Yet it didn't say a 23C. It just said a 23C date. And I'm looking for a 23C. So now, she didn't say that she certified that this was an amount, some certain, and I owed it. She just certified that all the records were there. So this couldn't be a certificate of assessment, right? It could be a certificate of assessments and payments, I guess, like they say it is. So I had some questions that had to be answered. So I wrote back, and I asked them, number one, I want to see the return that either I filed or someone filed them, that I filed and executed, or someone on my behalf filed and executed. I want a copy of that return. And I said, this is not a certificate of assessment, so I want the 23C, certificate of assessment. Here's the response. Response to Freedom of Information Privacy Act requests, May 28th. Internal Revenue Code 6203 provides for furnishing the taxpayer a copy of the record of assessment upon request of the taxpayer. Internal Revenue Regulation 301-6203-1 states that the summary record through supporting records shall provide identification of the taxpayer, the character of the liability assessed, the taxable period, if applicable, and the amount of the assessment. The certificate of assessments and payments represents supporting records as required by this regulation. This was forwarded to you on May 2087, under established procedures rather than pursuant to Freedom of Information Act. Regarding your requests for specific pages of your 75 and 76 returns, we have completed a diligent thorough search, but we're unable to locate these documents. We are sorry we are not able to provide you with them. This concludes our response to your request. All right, now, I had that in my hand, and I had this in my hand, right? And I'm reading what he says, and I'm reading what she certified on the bottom down here. Now, she certified that all the documents existed, right? And he's telling me he can't find them. Now, do you believe that he would purposely give evidence that she committed perjury? No, I wouldn't think so. He's not going to put her in, you know. So I'm thinking this, and I'm scratching my head, you know. And it took me about 10 minutes, and then it dawned on this thick German skull. It came through. So then I wrote back to them and asked them, also your response regarding the tax returns filed supposedly on 2/23/83 for the year 75 and 3/23/83 for 76 is rather ambiguous. Are you saying that there were never any tax returns filed on those dates, as the summary record of assessment says there was? Or are you saying that there was never any properly executed tax returns filed on those above named dates? Please clear up this ambiguity. All right, his response. As a result of receiving your latest inquiry, we again searched for the copies of the 75 and 76 tax returns you requested on May 87, and we're successful in securing them. We're enclosing them with this reply. Right? Well, I got to thinking, who in his right mind would sign a tax return saying I owed $640,000? Right? Nobody in his right mind would do that, would he? Because when he signs it, what is he signing it under? Penalties of perjury. So they sent me the returns. And here's a copy. They were both identical. One for 75, one for 76. The first thing I noticed on the return, across the top it said substitute for a return prepared by Audit Baltimore. Okay? Then it had my name and everything up here. No exemptions. Right? No line items. All right? And no signature. Is it a return? Is it a return? No. It can only be a return if it's properly executed. We're nothing there. All it says here is, well, the first thing I noticed at the top, there was all those long numbers that we saw on the transcript, supposedly, right? The supposed transcript. So then I matched them up, and they matched up perfectly. So then I understood all those long numbers obviously identify this document. Well, why couldn't they find it then to begin with? Because what? They didn't want me to see what? That it wasn't signed. They didn't want me to see that, obviously. Right? Okay. Later on, we find out that these numbers do identify it. It tells them exactly where it is. It shouldn't take them 5 minutes to go get it, which we'll show you a little later. All right, now, but it also shows us, right here, it says, received in February 23rd, 1983, but from Baltimore, and then received in Philadelphia. So evidently it originated in Baltimore, as it said, and went to Philadelphia. And it says, ROG sorted for statute REV, whatever REV means. And in April 12, 1983. And alongside of that, it had no statute determination. And it was signed. Now, what do those three words mean?
Couldn't determine what statute applied to it.
Well, a determination's a finding of fact, right? So, if there's no statute finding of fact, evidently there's no statute authorizing this. That's the conclusion that I jumped to when I read it, which later on proved to be correct. All right, so now let's go and we're going to investigate substitute for returns, IRS authority for executing returns for people who have requirements to do so and fail to do so. The code section we want to look at for that is 6020. Returns prepared or executed by the Secretary. 6020A. Preparation of return by Secretary. If any person shall fail to make a return required by this title. What's the title mean? The whole thing. The whole Internal Revenue Code. Or by regulation prescribed thereunder, but shall consent to disclose all information necessary for the preparation thereof, then and in that case, the Secretary may prepare such return, which, being signed by such person, may be received by the Secretary as the return of such person. Well, that's not the case here, is it? That's the case when they come out to your door and say, you didn't file your return, get the information out, or else they'll tell you to come on in, and they'll say, let's get the information here and we'll make a return up. But they didn't say, they didn't read your 6020A when they did that. They just said, you guys come in and do this. All right, so that's the first one, when you come in for an audit, or you not an audit really, but you come in and bring your records and you didn't file. Now let's look at 6020B, which is somewhat different. Execution of return by the Secretary. Authority of the Secretary to execute return. Up here, he can only prepare it, and the individual had to sign it, right? Or the person, be it a corporation, trust, or whatever. Down here, he can execute it. He can sign it. If any person fails to make any return required by any Internal Revenue law or regulation made thereunder, at the time prescribed therefor, or makes willfully or otherwise a false or fraudulent return, the Secretary shall make such return from his own knowledge and from such information as he can obtain through testimony or otherwise. Now, he can do that. If what? If what can he do that?
If you file a return.
No, if you filed a false or fraudulent return, he can do that. He can do that if what?
You're required to do it and don't.
If you fail to do it and you're required to do it. Right? He can do it under two circumstances. And he has to do it from what?
His own knowledge.
His own knowledge. Well, does his own knowledge carry over to your personal affairs? Well, quite possibly if you use a checkbook for everything. But let's say you don't use a checkbook. You know, the law doesn't require you to use a checkbook. There are legal tender laws where you can use currency. Right? So how can he have his own knowledge from currency? You know, you think and go, you know, I think of these things when I read these, you know, and I'm going, you know, I don't understand that. And then again, you would say to yourself, if I failed to make a return, who has the requirement to do so?
Secretary.
The Secretary. Well, if the Secretary has the requirement to do so, why would they charge me with failure to file? Huh? Is that right? Well, I mean, it's just common sense. He says he has a requirement. If I don't, let's charge him. How many people get charged with failure to file? Huh? I think we ought to report him under Title 18, Section 4. Don't you? Right. All right. Let's see where this takes us. Here we go. Now, to investigate this, we're going to go back to the manual. Where do we go in the manual? This time we go in 5200. What is 5200 of the manual? Delinquent return procedures. That's where we want to go, right? Because we have a delinquency. We didn't file a return. They did a substitute for a return. That didn't sound like a substitute for a return in 6020B, did it? But I couldn't find any section of the code that said substitute for returns is not there. There's a substitute return, but not a substitute for. Is there a difference? I believe there is. It sounds like it. And one's a substitute for a return and one's a substitute return. And there seems to be a difference. But anyway, let's go look in delinquent return procedures, which they tell the employees how to go about this. And let's go right down to general. That's in 5221 right here, right up in front. And it says, this chapter provides guidelines to assist in developing returns compliance programs and outlines methods by which staffing can be effectively utilized. Boy, that sounds bureaucratic, don't it? Okay. However, some of the techniques can only be used in connection with a full-scale program due to the nature of the tax situation and the need to avoid unnecessary taxpayer reaction. An example would be income tax returns compliance effort aimed at non-business taxpayers. What are they talking about? What are they? Let's read that again. It says here, however, some of the techniques can only be used in connection with a full-scale program due to the nature of the tax situation. What is that? What's the nature of the tax situation? And the need to avoid unnecessary taxpayer reaction. Why are they worried about that? If the law says it, hit them. Right? So why are they worried about reaction? And an example would be a non-business taxpayer. I think this really demands further review, don't you? It did to me. You know, you can get 5200. It's only a few pages. I think maybe 50 or 60 pages. And they'll give it to you for nothing if you write the FOA reading room over in D.C. They'll send it to you for nothing. It's a good one to have, just to have around. All right, now we're going to go to 5291, or 5290 and to 91. And 5290 is refusal to file Iowa Code Section 6020B. Now this is where the secretary can file for you when you have a requirement, right? Assessment procedure, 5291 scope. The procedure applies to employment, excise, and partnership tax returns. The procedure applies to employment, excise, and partnership tax returns. What's missing? Individuals are missing. Now you know why they say avoid unnecessary reaction from non-business taxpayers. Well, if the requirement is under the whole title, under 6020B, and he has a requirement to file, but the requirement only seems to relate to employment, excise, and partnership tax returns. Interesting, isn't it? Huh? Doesn't that intrigue you? I just love it. You know, I used to love it when I was on the police force and I would get my teeth into a good case where you could go around and dig up evidence. You know, I just love that. And this is just the same thing, man. You could just, It's like a good murder mystery, isn't it? Huh? I mean, you can really get into this. You know, I just love this. All right, look at this. Generally, the following returns will be involved. Generally, let me tell you something. It's only should be there. Here are the returns that he can execute. Form 940, Employer's Annual Federal Unemployment Tax. Form 941, Employer's Quarterly Federal Tax Return. Form 942, Employer's Quarterly Tax Return for Household Employees. Form 943, Employer's Annual Tax Return for Agricultural Employees. Form 11B, Special Tax Return, Gaming Devices. Form 720, Quarterly Federal Excise Tax Return. Form 2290, Federal Use Tax Return on Highway Motor Vehicles. Form CT1, Employer's Annual Railroad Retirement Tax Return. And Form 1065, U.S. Partnership Return of Income. What's missing? 1040. What was my substitute return? A 1040. Maybe there's more reason why it wasn't signed. Huh? There could be other reasons why it wasn't signed, wasn't it? Interesting. Well, now understanding this, what is the next thing we have to establish? Well, we have to go and we have to find out what's the authority for these things, right? Now, as we noticed the law, it said who can make returns? The secretary. Did it say the secretary and the commissioner and the deputy commissioners and assistant commissioners and all the employees of the Internal Revenue Service? No. It said the secretary can do this. Man, he's an awful busy man, isn't he? Right? But the law says what it says. Well, what we find out is that what he can do now, he can take that power given to him by Congress and he can delegate that to other with delegation orders. And he does this. He sends out Treasury directives, Treasury orders, to the commissioner. And then the commissioner, he takes and sends out delegation orders to the assistant commissioners. And they send out delegation orders to the service centers and the district offices, the directors of such. Mm-hmm. Now, so I wrote back and I said I want to see the delegated authority for this. Mm-hmm. And they sent me back delegation order 182. 182 is a national delegation order. And it says, authority execute returns. Authority granted Commissioner of Internal Revenue by 26 CFR 301-6020 and 26 301-7701 to execute returns required by the Internal Revenue law or regulation made thereunder when the person required to file such return fails to do so is delegated to revenue agents, tax auditors, revenue officers, collection office function managers, GS9 and above, to the extent the authority previously exercised consistent with this revision may require ratification. It is hereby affirmed and ratified. And then it's signed. Joseph Gwynn, acting commissioner. This is 1981. All right, but that didn't tell me anything, really, did it? So what I did was I wrote back and I asked them for the local delegation order issued by the director. I wrote to Baltimore and Philadelphia, who gave the authority to those under him. And I put in there which name the forms that they can execute, because I already knew under 5200 what the forms were. Now I just want to get it from the orders, right? So, got a response back that They had no such document. Didn't exist. From both of them, Baltimore and Philadelphia. So, we made a request to all the offices, and we got one back from Michael Perkins from Austin, Texas. And old Michael lets the cat out of the bag. This letter's response to Remeasurement Act request, delegation order 68, December the 19th, 1984. Encloses a copy of requested delegation order number AUCC 6, which replaced 68 order. Michael Perkins, disclosure officer. Here's the order he sent back. AUCC 6, 10-186, and delegation order, authority to prepare and execute employment and excise tax returns under the authority of 301 6021B of the Internal Revenue Code. All right, now this is more in line with what? 5200, isn't it? Right? The Revenue Officers Collection Division and all Collection Division managers, GS9 and above, are authorized to sign the employment and excise tax returns listed below, which are prepared and executed under the authority of 26 CFR 301-6021B of the Internal Revenue Code. Form 941, 942, 943, and 1065. This authority may not be redelegated. Okay. We also got one back from Oklahoma City. Here's the letter from Oklahoma City. A copy of the revision 5, which superseded the previous order of November 27th, 87. Here's the order. Now notice here, authority to execute return, 6020B, Internal Revenue Code, behalf of the District Director, 940, 941, 942, 943, 11B, 720, 2290, CT1, and 1065. Where's the 1040? Interesting, isn't it? Don't you think they love these kind of requests? Don't you think the Internal Revenue Service likes it when these guys hand out stuff they're supposed to say don't exist? Now, so far, all we found is the ones that are listed in 5200, haven't we? That's it, isn't it? I mean, that's all we've gotten so far. All right, so now I wrote back to Philadelphia and Baltimore, and I sent them copies of Oklahoma City and Austin, Texas.
And they've since retired, I bet.
No, they're still around.
Got promoted.
Yeah.
So, I think we still have Michael Perkins, and we still write to Michael Perkins, and we still write to, there's a guy, Nichols, still write to him. Yeah, they're still around. I think Michael Perkins is somewhere else now. We're in Kansas City or somewhere. Where? He got transferred, but any which way, they're still there. So then I wrote back and I sent them copies to Philadelphia and Baltimore. One I got from Oklahoma to Baltimore and one to Austin to Philadelphia. And I said, would you please send me your counterpart to this? And they wrote back and said, we have no such delegation order. All right? So now what do? What would you do? You know, does this stop our investigation? Of course not. What do we do? What would you do in that case?
Right to.
Yes, before any authority.
This is perfect.
Are you being too specific?
Now, what would you actually do in that case?
Go to the secretary and ask them to send it to 1040.
Here's the request that I made to Philadelphia. Say it. This request pertains to the enclosed copies identified with document locator numbers so-and-so and so-and-so, which are the two tax returns, right? Please send me a copy of the Delegation of Authority, Mid-Atlantic Region, Internal Revenue Service personnel to prepare and execute the enclosed documents identified with these numbers as returns under Section 6020B Internal Revenue Code. Now, we know it's 6020B because he sent me 182, right? Is that correct? Please send me a copy of the document which identifies the person and their title who prepared the above identified documents. Huh? Response to Freedom of Information Act request. We are unable to find any delegation order concerning the authority of execution of returns subsequent to 182. We also cannot find any list of tax forms as such regarding 182. You previously requested document 6209, which may be obtained from the National Office of Freedom of Information Act, Privacy Act section. There is a photocopying fee required for this service, etc. Response to Freedom of Information Act request July 88. We are forwarding Delegation Order 182, right? Authority to execute returns. We are unable to find any redelegation order. We have searched our files thoroughly, but we're unable to locate any document which identifies the persons or titles who prepared the documents. Appreciate the opportunity to serve you. Wild, huh? You think the government lies? Employees lie?
That's a violation of the FOIA Act.
Of course. Of course. Were you here when I?
No, I've done them before.
No, I say, were you here when I read the I just motioned to strike. Were you here when I read about this? Huh? Interesting, isn't it? 518 days, and he writes it as though I got it 518 days ago. What a. All right. Now, so what happened? Well, the first thing I did was I wrote to Washington, D.C. to Ellen Murphy. And Ellen Murphy she's Assistant Commissioner of Public Affairs. So if you want to know anything, how many saw 2020 when they had Phil Marsh at the Pilot Connection on there? Remember that big gal from the IRS? That's Ellen Murphy. That's who they put on there. She's a big one. But I don't mean stout. I mean she's tall like Janet Reno. I mean she's a big build. She must be 6'6", it looks like. But anyway, she's helpful. At least she was in the beginning. Here lately, she hasn't been so helpful. But in the beginning, she was very helpful. And I asked her. I said, "Could you tell me if the Internal Revenue Code and the Internal Revenue Regulations and the Internal Revenue Manual is applied equally in all the offices within the states of the Union?" All right? So I got a response back, and it said that, from one of her lawyers, and he said that it is well known that if you ask questions in different offices of the IRS, that you'll receive different answers. This is beyond our control due to individuals, etc. So I wrote back and I said, "No, you did not understand my letter. What I said is the lawful effect of the Internal Revenue Code and the Internal Revenue Regulations and the manual applied equally to its intent throughout all of the offices." And he wrote back and he said yes. So that means if Austin, Texas, and Oklahoma City have a delegation order, then there should be one in Philadelphia and Baltimore, right?
And they should be identical.
And it should be at least to the substance. Every word doesn't have to be identical, but the substance should be the same, right? So anyway, he wrote back yes. So then the next thing we did was we wrote to every office of the Internal Revenue Service and we asked for every delegation order they had. All right? This is quite a task. If you don't believe me, ask John Mark. He's doing it now. right? I mean, it can eat up a lot of your time. I mean, days can be engrossed in that. So all of a sudden here, all over the country, these delegation orders, big envelopes of delegation orders started coming in. All the delegation orders they had. And Lord and behold, they came from Baltimore and Philadelphia too. And when it came, man, when I got that one from Philadelphia, I couldn't wait to look through it. And you know what I found? I found the man is a fibber. Evidently, they forgot to pull it out before they sent me all the delegation orders. Here we have delegation order number 70 from Pennsylvania, Philadelphia, Pennsylvania. And what does it say? Authority to execute returns. This is the one I just showed you where he wrote and said it didn't exist. He couldn't find it. He didn't have any trouble finding it now, did he? Of course, this was like 6 to 8 months later. Maybe he forgot. Purpose: to redelegate authority to execute returns to unit managers GS9 and above, Service Center Collection Branch Compliance Division. Authority: Delegation Order number 182, 79, Internal Revenue Manual 5452-10-1. All right, but he didn't list the returns, did he? Didn't have to, because we now go to 5400, Service Center Collection Branch Procedures, and we look at it in 5452-10-1, which is their authority. And what does it say? Delegation Order 182 extends to Service Center Directors the authority under IR Code 6020B to prepare returns that are required by any Internal Revenue law or regulation when the person required to file does not. All right, this goes on for a few pages, but you see the returns in here. You got a 941, 942, 940, 2290. I'll give anybody here $1,000 on the spot to show me a 1040. You can go through them, show me the 1040, I'll give you $1,000 on the spot. I've been offering this for how many years now? I haven't lost it yet. I could throw up another page. He's got more of them on there, but no way, Charlie Brown. Yeah. It does say down here that send the original letter 1085 SC or 1616 SC and prepared returns to the taxpayer. TP stands for taxpayer. See what it says down there? When they do a one under 6020B, they got to send you a copy of the return, and they got to send you either one of these letters. So I made a request for a copy of these letters, because they told me it was 182. 6020B was their authority for the return, yet I can't find that. And they didn't have a copy of those letters to send me? Now they threw this in the middle of it. For whatever reason, I don't know, but I just showed you to show you that I didn't skip any pages. This is Power of Attorney Declaration of Representative. It's a form, a 2848. I don't know why they put that in the middle of that, but they did. It's just an IRS way of doing things, I guess. But here's the rest of the page. Right here, and we still can't find a 1040. Right? You see the letters again. See, they got to send these letters. Of course, they didn't send me one. And we come on down, there's more reference to different forms, but no 1040. All right. So what are we starting to put together? Do you think this is a daisy chain? I think it tends to show evidence that quite possibly they didn't have the authority they cited. Particularly when you go back to 5200 delinquent return procedures, and here you come down here to substitute for return procedures. See it? Let's look at substitute for return procedures. On October the 1st, 1986, collection was delegated the authority to assess an IMF tax. IMF stands for Individual Master File. And the Service Center Collection Branch started substitute for return SFR processing. Essentially, an SFR assessment is an audit. An SFR assessment is an audit. An assessment is an assessment, an audit's an audit. I think audit goes before assessment, don't you think so? But here they have it reversed. Process, where the initial action of the Service Center Collection Branch is to file a real return for the taxpayer. Huh? No, it's not real? No, it's a dummy. To file a dummy return for the taxpayer for zero amount and then assess the tax with a TC, transaction code 290. The assessment is based on the IRMF, Information Return Master File, for formerly IRP, information from the TDI, Taxpayer Delinquency Investigation Supplement File, IRM transcript. But you can see it's the substitute for return is a dummy return. Well, what the world does that mean? Is a substitute for a return the same as a substitute return? No, it would be two different things. A substitute return would be under 6020B. But that's a real return because it's signed, right? Or is it signed? It did say executed. He has to execute it. That's what the statute said. But here, it's talking about a substitute for return that's a dummy return. Well, a dummy return would not be signed, would it? Now, another page of 5200, signing of tax returns of 5293.3. The following statement shall be typed or printed on the bottom of the return. This return was prepared and signed under the authority of 6020B, the Internal Revenue Code. Do not assess failure to pay. All right? Now, that's not a dummy, is it? No. Because it has a signature. But yet the other one's a dummy. What the world do they mean by dummy?
No signature?
No signature. Well, back here they said that this started in 1986, October the 1st, 1986. What we did was we wrote to all the offices and asked them for a copy of that delegation order, dated October the 1st, 1986, and all we received back were responses saying no such order exists. There is no delegation order with that date. All right? So then, later on, as we started checking the manual, we found that what they were talking about is substitute for returns being dummy returns are under delegation order number 77, which is the authority for section 6212, which we covered a little earlier, and 6212 is deficiency. So when you have a deficiency, you have to have what? When there's a deficiency assessment, what has to happen?
They have to assess you based on...
Well, there has to be assessment, but there had to be what? Somebody said.
A return has to be...
There has a return has to be filed before there's a deficiency within the return, right? All right, well, we found that was the case. A return was filed. The IRS either lost or destroyed the return, and thereby they contacted the taxpayer and created a dummy for the lost or destroyed return. So we have a dummy return. Well, in most cases, that didn't happen with a lot of people in here, did it? Because there was no return filed. All right, when there's no return filed, then you have the procedure which we just showed you under 6020B. If, indeed, the return comes under 6020B. Now, we just saw a little while ago, did a 1040 come under 6020B? No, not according to 5200 delinquent return procedures, did it? Right? No way. So there's two different procedures. One is 182, where the return is signed and they have the authority, and the other one is 77, where all they're doing is trying to verify a deficiency within a return that was filed, and therefore you can understand they don't need to sign that return because they received the information from the party who filed the return. All right, now, talking about delegation orders, in 1954, there was a radical change to the Internal Revenue Service. The Reorganization Act of 1950 was instituted in 1954 with the 54 Code. And what happened then, the Internal Revenue Service received a new boss who was the Secretary of the Treasury. From 1862 all the way up to 1954, it was the Commissioner of Internal Revenue who was the boss of the Bureau of Internal Revenue. Well, in 1954, the Secretary of the Treasury took over, and it got a new name called Internal Revenue Service. That all happened with the Code of 54. Now, of course, there had to be delegation orders, right? Because now we have a new boss. So the Secretary of the Treasury had to give delegated authority to the Commissioner of Internal Revenue and right on down the line. Now, delegations of authority are published in the Federal Register. Everybody know what the Federal Register is? Does anybody here doesn't know what the Federal Register is?
Comes out every day.
That's right. The Federal Register. Well, the Federal Register is where bureaucrats publish regulations and anything that affects United States citizens within the states of the Union as an operation of law. So, in other words, the Congress doesn't pass regulations. Bureaucrats write them to implement code sections. Well, a delegation order would still be implementing a code section. So, therefore, when they write these delegation orders, they have to publish them in the Federal Register, and the citizens or Congress has 30 days to move against the regulation as being unlawful. Or if they don't, within 30 days, it has the force of law. So that means every delegation order that has any effect on United States citizens with an operation of law has to be published. Now, we moved for the delegation orders to for the authority to go from the Secretary to the Commissioner of Internal Revenue. And one of them was Treasury Department Order 150-37. And we would, and 150-10 too. We would take and request these, and they couldn't produce them. We looked all through the Federal Register, and we couldn't find them. All right? So finally, we received this one here. A copy from Internal Revenue Service, Disclosure Officer, and it says, the Department of the Treasury Order, April the 22nd, 1982, number 15010, subject, delegation responsibility for internal revenue laws. By virtue of the authority vested in me, Secretary of the Treasury, including the authority in the Internal Revenue Code of 1954, the Reorganization Plan 26 of 1950, it is hereby ordered the Commissioner of Internal Revenue shall be responsible for the administration and enforcement of the Internal Revenue laws. Commissioner Order Number 190 and General Counsel Order Number 4 state the powers delegated to the Chief Counsel for the Internal Revenue Service. All outstanding orders and delegations of authority relating to the above are modified accordingly. This order supersedes Treasury Department Order Number 150-37 dated March 17, 1955. Signed, Donald T. Reagan, Secretary of the Treasury. See his signature? Huh? You see his signature? All right? Isn't that interesting? But you know, this was never published. And down here at the bottom, there's some numbers here the printer put on here. All right? So we're going to look at them. I blew them up for you. give you an idea how these people tell the truth. And you'll see that this stationery was printed on November of 1985. Right? The letterhead was printed. This letter was written on. But what is the date of the letter? 1982. That's a pretty good trick, right? Writing on a letter on stationery was printed 3 years after the letter was written. Paper was printed. I like to learn that trick. That's pretty good. But that just shows you how they continually bathe themselves in honesty and truth. Now, in the same vein, we're still talking about assessments and levies and the like. And here we're talking again about 6020B. This here was sent in by one of our members in California who received this from a disclosure office in Sacramento. Here it says, we would also add that substitutes for returns are not prepared in accordance with IR Code 6020B. Finally, we have an IRS employee telling the truth, right? All right. They are used to establish an account for the master file so that deficiency procedures in accordance with IR Code 6211, 6212 can be followed. Well, that's what we found out about dummy returns, right? So 182 is 6020B, and 6212 is Delegation Order 77. And they're different as night and day. One is a delinquent return, and the other one is a deficiency on a return that was filed. All right, well, let's go examine these code sections to see what he's talking about. Here we have 6211, a definition of a deficiency. In general, for the purposes of this title, what's that word title mean? It means the whole Internal Revenue Code, right? Title 26, right? In the case of income, estate, and gift taxes imposed by subtitles A and B, and excise taxes imposed by chapters 41, 42, 43, and 44. What subtitle are they in? D, that's correct. They're in D. What is D? Miscellaneous excise tax. The term deficiency means the amount by which the tax imposed by subtitle AB, or chapters 41, 42, 43, or 44, exceeds the excess of the sum of the amount shown as the tax by the taxpayer upon his return. Is that right? Now, if something's wrong here, that guy must lie too then. Nobody tells the truth.
In this tape, we examined the legal requirements for withholding agents and showed that the law does not require the income tax to be withheld from U.S. citizens. To the contrary, we showed that the income of U.S. citizens living and working within the 50 states is not the subject of the tax, and that the law requires withholding agents to collect income tax only from non-resident aliens, foreign corporations, and certain foreign organizations. Under Section 1461, the withholding agent is made liable for the tax. However, it should also be pointed out that the withholding agent is the only person made liable for payment of income tax. Therefore, the income tax laws are extremely limited in their application, and this is also why the income tax is constitutional. However, it remains constitutional because Congress never intended to enact, nor did it pass any legislation that would subject the income of U.S. citizens within the 50 states to a tax on their income. During the course of showing how these laws were actually applied, we also reviewed the term taxpayer as it is defined by law, and found that the law defines a taxpayer as a person who is subject to the requirements of the Internal Revenue Code. Since the withholding agent is the only person made liable for the income tax, the withholding agent is the taxpayer. But we also explained that the withholding agent's liability to pay an income tax is often confused with the voluntary contributions made by citizens who willingly participate in the Social Security entitlement programs. We were careful to emphasize, however, that participation in Social Security is voluntary because there is no law requiring a U.S. citizen to apply for a Social Security number. Indeed, a law such as this would be unconstitutional. And while the law may require certain non-resident aliens to have a Social Security number, U.S. citizens need not apply unless they want to obtain a benefit from the program. We also reviewed the nature of the tax court and explained that the tax court is not a court of law. The term is deceptive because the tax court is merely an administrative appeal board within the Internal Revenue Service. In other words, the IRS and its quasi-court are not part of the judicial branch of government, and decisions of law are beyond the scope of tax courts. We then examined procedures that were written to implement certain provisions of the law and found that the tax laws are often quite different from what the IRS represents to the public. We explained, for example, that there is no law that would give the IRS the jurisdiction to assess a tax against the income of a U.S. citizen, and that to do so, the IRS misapplies the law and circumvents proper procedure. To illustrate how agents of the IRS subvert the law, we looked at the requirements imposed on the Secretary of the Treasury in the Internal Revenue Code. According to Section 6020, for example, when someone fails to file a return, the Secretary must execute and sign the return that is required by law. However, we also learned from Section 5291 of the Internal Revenue Manual that required returns include only employment, excise, and partnership tax returns, not 1040s. We verified this by examining the legal provisions that limit the scope of such actions and found that the Secretary delegates his authority for administering this and other laws to employees within the IRS, and that authority is conveyed via documents that are called delegation orders. Once a delegation order has been issued, certain IRS employees may act with the authority of the Secretary, but only within the limits specified by the delegation order. Of course, IRS employees do not necessarily obey the law, nor do they limit their activities to those specifically enumerated within the delegation orders. And many people have found that despite the absence of legal authority, IRS employees fake the execution of 1040s for those who do not file, which, by the way, presents an interesting dilemma for an agent who is asked to show the authority for such action, especially when the agent discovers that there is no delegation order to authorize the filing of a 1040. To the contrary, we showed the list of returns that were required and found that the only income tax returns that could be executed by the IRS were those employment, excise, and partnership returns that are required from employers and businesses. That's why the IRS warns its agents in the Internal Revenue Manual to avoid unnecessary taxpayer reaction from the non-business taxpayer, because of what they choose to refer to as the nature of the tax situation. Under the circumstances, the many references made by the IRS to voluntary compliance would seem appropriate. And finally, we explained that regulations that are written by agencies of the federal government must appear in the Federal Register so that citizens can have 30 days to challenge newly proposed laws. Or perhaps more importantly, if a proposed regulation does not appear in the Federal Register, then it is a foregone conclusion that the proposed law is sufficiently limited in its application and does not apply to U.S. citizens.